if the court says that my so reason in our court, I don't think cannot be a crime. If another matter comes before it, the ratio that is the reason for the decision in that case can apply in that matter, provided we have similar fact. And when we say similar fact, we mean that for a court to be bound, for a lower court to be bound by decision of higher court, it must ascertain first of all that everything that happened in the previous case have similarity with the present case. In other words, if adultery is an issue in Awko and Fagbemi, for the court to adopt the decision in Awko and Fagbemi as binding on the lower court, let me say now it is the Supreme Court that made that judgment. We discover the private and that is where we have what we call ratio stand. We have Obiter. My handwriting is so sweet. So when we talk about the ratio on today's video, which is our 4th lecture series on introduction to second semester 1, we shall be considering what the doctrine of judicial precedent. On our first lecture video, we discuss everything that has to do with what? Sources of law. From there, on the second part 2, we talked about then what? The primary sources and the secondary sources as the basis when lecturer will test you on second semester. Then, on the third one, we discussed the hierarchy of court. And it is that hierarchy of courts that led us to talk about the doctrine of judicial precedent. The doctrine of judicial precedent is very, very important to any lawyers and every law student. And on the course of this discussion, you are going to see why I say so. By the way, you cannot understand the doctrine of judicial precedent without looking into hierarchy of court. That's why every time on this YouTube channel, I structure my video in such a way that each one flows with the other. Because I know the implication of jumping one step and moving to another step is going to affect you. But if you have watched our first video on hierarchy of court, you will understand when I begin to delve deeper into this thing. However, if this is the first time you are joining, I encourage you to subscribe to this channel, King's Advocate Network Law Made Simple, because what I do here is that every Wednesday and Friday and Saturday, I used to post a tutorial video, and the only way you can receive it like a WhatsApp notification is when you are subscribed. It doesn't cost anything. Once you subscribe, you are just telling YouTube system that whenever this guy posts a video, notify me. So subscribe so that you stay updated. My name is Kingsley. I'm currently in my 400 level, and what I do is to help fellow lawyers. Now, let us move to doctrine of judicial precedent. When we say doctrine of judicial precedent, what do we mean? Doctrine of judicial precedent is a principle or a doctrine that suggests that the authority of the higher court is binding on the lower courts. Another name for it is what? Stare Decisis, which translates in English means let the decision stand. Stare Decisis is a Latin phrase that means let the decision stand. Then another name for it is also known as what? Case laws. So when you call case laws, you call doctrine of judicial precedent, you call the Stare Decisis, you are referring to what? That the judgment of a higher court is binding on lower court. And the lower court is bound by the decisions of the higher court. Now, how the doctrine of judicial precedent emerged? That is the question that any typical viewers will be watching. The doctrine of judicial precedent emerged based on the fact that during the time in the era of common law, I have made a video that talks about that. It's still on this channel. If you type common law and equity by King's Advocate, you are going to have it. Now, remember we are told that common law and law in it generally originated from the fact of Norman conquest and all those things. So when the Roman Empire were the world power, many people don't know that Roman Empire were once the world power. So during that time they were world power, they were ruling. So when they conquered the Britain and all those things, they were administering them. There were judges. They constituted judges in order to ensure that that territory is well managed. So as the judges are delivering judgments, if Okeke and Okonkwo come, or Mr. Taiwo and Ahmed comes before the court, and the court deliver a judgment, what the court will do is that the court will jot it down. The court will compile it down. Remember, the court in the English court then, when they want to give a judgment, they write it down. So as they are delivering the judgment in writing, that document, they begin to pile it up. Now, as they begin to pile it up, let me see, they deliver between Taiwo and Okeke, they pile it up. They deliver between Ahmed and State, they pile it up. As they do that, they pile it up until it gets to a limited extent. Now, what happened is that the judge say, instead of us that every single day we'll be deciding a matter, that this thing have led to what? Chaos. Because, come to think of it, you will come and complain that somebody is taking your wife. The court say that, okay, based on this, you should not take Okeke's wife. Now, tomorrow, they took Taiwo's wife. Taiwo would then run to court, hoping to get what Okeke got during his own time. But the court will say, no, we are not giving you what we gave Okeke. Then that thing begin to raise a insinuation that the court discriminates. Are we together? This story is very important to understand the origin of this thing. Trust me, I'm not joking here. So, so you can't be like saying a para for you, sorry. So now, as this thing begins to go on, the court, you took my land as Kingsley, I will run to court and the court will give me favor. Then when Taiwo come, that somebody took their own land, the court will give a similar or different thing. Then the court say no. To put certainty to this, so that anybody that is coming to us will even possibly foreshadow what he's going to get. Let us do something. They then begin to say, okay, if the issue between Kingsley and Taiwo has happened, let us not throw what's happened there away. Let us compile it so that any other person that has similar issue that comes to us, we will single-handedly apply what is obtainable in Kingsley and Amin to ensure there is certainty, to ensure there is no discrimination, to ensure that the law remains that lady of justice raising her sword and then raising her knife and then blinded. So the blindness of lady of justice shows that the law doesn't look any person. The law is not respecter of principality or power. That is why lady of justice is totally blind. Now the court says to ensure that whatever a man will sow is what he reap, and whatever a man wants to reap is what he sow. Let us have doctrine that will ensure that whatever we decide will be consistent. So the doctrine of judicial precedent is rooted on what? Predicability. They want to predict the law. They want to ensure there is certainty. They want to ensure that the law is flowing in a directional form. That is how we got the doctrine of judicial precedent. Are we together? Then that reminds me, most of you people that used to watch my video without reacting, what is the problem? You watch this video, you can't even give me a like. It's not fair. So like this video as I'm talking now. Like the video, let's continue. Have you liked the video? Thank you so much. Now, when we are talking about the doctrine of judicial precedent, the key thing that you are going to know is the hierarchy of court. I have made a particular video dedicated to it. So the doctrine of judicial precedence means that the judgment of the Supreme Court is the last resort. So whatever Supreme Court decide is final. Whatever Court of Appeal decide is subject to Supreme Court. Whatever Federal High Court decide is subject to Court of Appeal. Whatever State High Court decide is subject to Court of Appeal. Whatever Industrial Court decide is subject to Court of Appeal. Whatever Customary Court decide is subject to what? Court of Appeal. Subject to Court of Appeal. Subject to Court of Appeal. Subject to Court of Appeal. Whatever Sharia Court decide is final. Final. On Islamic legal matter. Final on Islamic legal matter. Final legal matter on Islamic affair. The bone of contention here is, if Supreme Court decide a matter, you are only going to appeal to Father Abraham or Prophet Muhammad. Are we together? Once Supreme Court decided, it is finished at the last time. But if it is cause of appeal, you can have the option to go to Supreme Court. Are we together? If it is Federal High Court, you can go to what? Court of Appeal. If it is State High Court, you can go to what? Court of Appeal. That is it. Now, these things are regarded as the superior court of records. We have the inferior court of record. So when you come here, whatever magistrate court decide, you go to State High Court. Whatever district court decide, you go to what? Sharia Court of Appeal. And the difference is that I don't want to teach this thing. Please, after this thing, you go and watch my hierarchy of court. Just type on YouTube, hierarchy of court by King's Advocate. By the way, anything you want to discuss or you want to search for, just type it, the name of that topic by King's Advocate. King Advocate. Once I have made a video on it, it's going to show on your YouTube. It's simple as that. Just whenever you want to read and you are confused, type that topic by King's Advocate. If I have made a video, you will see it. Now, when we are talking about magistrate court and district court are the same thing, but this one is in the north, this one is in the south. Sorry, this one is in the south, this one is in the north. So whatever this one decide goes to State High Court in the south. Whatever district court decide goes to Sharia Court of Appeal. Whatever area or upper court decide go to Sharia Court of Appeal. This one and this one is the same. This one and this one is the same. Sharia court and area court is the same, but the difference is that customary court is on the south. Remember, the north don't deal on customary law. They have only Islamic law, and Islamic is not customary. They are written down. Customary law is not written down. So whatever area court, on the other hand, is a court that has similar characteristics with customary court, but this one is dealing, area court is dealing on what? Sharia law. Why customary court is dealing on our customs. Then any decision you are moving from customary court, if customary court give a judgment and you are not satisfied, you go to customary court of appeal. If area or upper court give a judgment and you are not satisfied in the north, you go to Sharia court of appeal. If Sharia court of, then we have Sharia court again in the north, different from this one. So if they give different again, they go to Sharia court of appeal, and whatever Sharia court of appeal decides is the final for the northern brothers. As far as the 12 states that are operating Sharia law, that is only when it's applicable. Some states in the north that are not operating Sharia law may be dealing with state high court and all those things. But in the south, if a customary court of appeal decide, that is, if the customary court is not in your favor, you go to customary court. If customary court is not in your favor, you go to customary court of appeal, and it's not in your favor, you move from here. You go, you go to court of appeal. Whatever court of appeal says, no, you are not satisfied, you move again. You go, you go to Supreme Court. And then whatever Supreme Court decide and you are not satisfied, you move here, and go to heaven. So, but when you are talking about then state high court, all these ones, they are court of record. Why this one is inferior court of record? I have discussed more on it when I'm dealing with what? Hierarchy of courts. But the bone of contention I want you to take is that when we are talking about judicial precedent, we are talking about the fact that a lower court under hierarchy of court is bound by the decisions of the higher court. And the benefit is to ensure certainty. So for the sake of this thing, let us consider authorities that are what? In judicial precedent. Now, what we are going to do now we have fully known how this thing works. Let us then consider
law confusing. Let's make it simple. At lawmadesimplelegal.com, we break down the hardest legal concepts into easy-to-understand lessons. Whether you're a student, lawyer, or just curious, you'll find clear explanations and real case analyses across fields like criminal law, contract, tort, and constitutional law. This is where law becomes easy and practical. This platform was created by Kingsley Omenyi, simplifying the law for Nigerians and beyond. Visit lawmadesimplelegal.com or simply scan us on Google to discover how easy law can be.
How the judges are bound by decision, because we are fully undergone this. Let us talk about the bindness of them. So we turn our board now to another thing altogether, so that we can possibly get the full gist of today's discussion. So now we want to do how are courts bound, how courts are bound by case law, because it will be shorter. Now, when we talk about how courts are bound by case law, what I want you to understand that we have persuasive precedent and binding precedent. Persuasive precedent and binding precedent. You will definitely like my handwriting. You know, we that are so intelligent, we will write like professors. So when we are dealing with persuasive precedents, what I want you to get here is, it is not every judgment of a Supreme Court, it is not every judgment is binding on a lower court. This is how it works. Assuming Supreme Court gave a judgment, the lower court is bound by it. But what happened when State High Court gave a judgment, like we saw that time? State High Court gave a judgment. State High Court of Enugu State gave a judgment. Anambra State gave a judgment. Then Kogi State wants to rule on the same matter. And then some lawyers are citing what is decided in Enugu, what is decided in Anambra. What will Kogi High Court do? The authority cited, if Kogi government or High Court is decided on a matter and the lawyer cited what is decided in Enugu and it has similar fact, Kogi State High Court is not bound by it, but can be persuaded by it. Are we together? So any court, what we call it is court of concurrent jurisdiction, meaning that State High Court of Anambra and State High Court of Enugu, they share concurrent jurisdiction. Nobody is bigger than the other. It's just like mama and papa is bigger than children, but children are equal regardless of age. Age may vary, but they remain equal. So whatever now that the Supreme Court want to give as a judgment, whatever now that Kogi State want to give as a judgment, and you are citing authority of Enugu State High Court, is just persuasive. The judge can take it or not take it. The judge can go with it or rule his own. It is persuasive. But assuming it is court of appeal, be it court of appeal in Enugu, be it court of appeal in Anambra, be it court of appeal, because court of appeal is in region. We have court of appeal in Abuja, we have court of appeal in Lagos that covers the west, and Ibadan too. We have in Enugu, and then we have in Port Harcourt. Before it was the one in the each start geopolitical zone, but I think it's now more than 2. But what the gist is, court of appeal remain court of appeal. If a single court of appeal in Lagos has given a judgment, the court in Enugu or the court in Enugu is bound to oblige to regard that judgment. Same thing applies. Supreme Court is one in Abuja, but Court of Appeal has jurisdiction or divisions, but they are not different. They remain Court of Appeal. But State High Court are different. They share similar jurisdiction, but they are not connected. So you cannot say that a judgment of Anambra State High Court is binding on Enugu. It is persuasive. Then when you talk about binding precedent, they are the one given by the Supreme Court. They are totally binding on any court. The one given by Court of Appeal is totally binding, like I told you, in their hierarchy. Now, another thing we are going to consider is, how do you discover the part of judgment that are binding? How do you discover parts that are binding? For the sake of limitation of this board, parts binding. How do you discover the parts that are binding? That is where we have what we call ratio Decidendi. We have Obiter Dictum. My handwriting is so sweet, guy. Obiter Dictum. So when we talk about ratio Decidendi is the reason for the decision. Somebody say the reason for the decision. Reason for decision. Oh God. Decision. This one is the comments, by the way. Comments, by the way. In the shorthand, I'm writing shorthand. So Obiter Dictum is the comment, by the way. Ratio Decidendi is the reason for the decision. Now, when we talk about ratio Decidendi, this thing you understand it better when you grow, because I know some of you have not started reading law reports if you are in year 1 watching this video. But if you read law reports, you observe that for the judge to give a judgment, they will say a lot of things. They will start by talking about the case, the fact of the case. When we say fact, we refer to what happened in the case. So when the law state, they will talk about that the counsel to the appellant cited this, the counsel to the defendant cited this, the counsel to the plaintiff cited this. By the time they are done, they said, okay, this so law is not the correct law. This so law is the correct law. Whatever they say, all those kind of camouflage they will say, because you don't just go and say, I rule that Okeke is the owner of the land. You must say a lot of things. All those things that are saying just to support the main reason of their decision is what we regard as Obiter Dictum. I have made a video on these two topics, ratio Decidendi and Obiter Dictum. Trust me. If you have not watched that video, I encourage you to go to the description box after this and click it and watch it, because I'm not going to say everything here, but clear thing just to teach this in what I'm going to say. But if you go there, you see even cases I use for example. These are how you learn. This is why I encourage you to subscribe. This is why I even encourage you to subscribe, because more is coming here. Now, when we say Obiter Dictum, when we say ratio Decidendi is the reason for the decision. Okay, if the court wants to give a judgment that adultery is not a crime in the southern part of the country, they are basing their judgment on the fact that there is no express law that provides that adultery should be made a crime. And remember, section 36 say that any person to be convicted for a crime, there must be a clear definition of that offense and punishment provided to that offense. So in a situation whereby the court based their reason that by virtue of the fact that there is no written law banning adultery, therefore adultery cannot be regarded as a crime, that is the ratio Decidendi. That is what forms the decision in Auko and Fabweni. So the essence of this is that The ratio Decidendi is the reason of the judgment. The Obiter Dictum is the comment by the website. Now, the implication of studying it is to do what? How courts are bound by case laws. Do you understand? That is why we are studying it. What is paramount here? What is paramount in this teaching is this. A court of hierarchy, under hierarchy of courts, a lower court is bound by the decisions of the higher court. The higher court in this case means that if the Supreme Court, let us assume this thing is Supreme Court, the Supreme Court have given a judgment, the lower court is bound to apply it. But that does not mean that everything the Supreme Court decide is what the lower court is going to sheepishly adopt or take. Are we together? The lower court still possess some measures upon which it can ensure that it doesn't follow everything that Supreme Court decide, hooks and sinker. What do we mean by that? It is the ratio Decidendi of a higher court is what binds the lower court. Do you understand? So if the court says that by so reason in Auko and Fagbemi, adultery cannot be a crime, if another matter comes before it, the ratio, that is the reason for the decision in that case, can apply in that matter, provided they have similar fact. Now, when we say similar fact, we mean that for a court to be bound, for a lower court to be bound by the decision of higher court, it must ascertain first of all that everything that happened in the previous case has similarity with the present case. In other words, if adultery is an issue in Auko and Fagbemi, for the court to adopt the decision in Auko and Fagbemi as binding on a lower court, let me say now it is the Supreme Court that made that judgment. Then, for the lower court to be bound by it, it must make sure that the case before the lower court is the one that deals on adultery as a crime. So it does not lie in the mouth of the lower court judge to adopt the judgment of the Supreme Court as binding or Court of Appeal as binding on it when the facts are dissimilar. So for the court to adapt the judgment of a higher court, everything must do what? Align. And if everything doesn't align, the court cannot be bound by it. The implication is there is one popular case I often use as an example. That is the case of P2B, Atiku, and Tinubu and others. In that case, one of the issues forming part of the appeal, both from the Presidential Petition Tribunal and that of the Supreme Court, is that it has to do with on what? Whether you have to win Abuja for you to become a president. Now, the Supreme Court held that Abuja should not be treated as a state, meaning that you don't have to win. If you have won all states across the federation or have win two-thirds of majority to become a president, as provided that you must win at least majority vote to become a president. For the fact that you didn't win Abuja does not in any way negate the fact that you can become a president of a country. This was the issue covered. This was the issue addressed, and this was forming part of the judgment. So if any other matter comes up in 2027, remember this issue was addressed in 2023 general election. So if any other matter comes up in 2023 general election, the court will simply go in there and apply the fact that there has been an authority in P2B, Tinubu, P2B, Atiku, and Tinubu and others to decide that 2027 coming case. It can be Presidential Petition Tribunal because they are the court of first instance on presidential office of the president when it has to do with issue surrounding office of becoming a president. But that is what the court will do. So what I want you to take away is that if you are discussing hierarchical courts are bound by law, the lower courts, whenever it is faced with the authority of Supreme Court or what? Court of Appeal, it is bound to apply it. And when we are referring to lower court, we are talking about state high court, we are talking about all those little courts. Do you understand? So that is how the hierarchy of court work. But then whenever a court don't want to follow sheepishly the decisions of the higher court, they must use what we call distinguishing a case. Distinguishing a case simply means what happened in the other case is not what happened in this case. Therefore, I am free to give another different judgment altogether. That is what distinguishing. With this, I can believe that you can now probably predict how courts are bound by case law. Now together, this is how purely courts are bound by what? Case law. And trust me, every other thing we are discussing is forming part based on this idea. On our next lecture video, we shall then go detail again to talk about second semester topic. But if you have missed a lot of all the video we did, you can click above, the link comments above, so that you'll be able to watch it. I encourage you to subscribe and like this video, and together let's continue to grow the legal knowledge.